Welcome and thank you all for coming to this third event of this year's Berkeley Tanner Lectures. Our Tanner lecturer has been Professor Annabel Brett of the University of Cambridge, who's been speaking to us on the times of possibility. And her commentators have been Professor Melissa Lane of Princeton University, and regrettably, by Zoom, Professor David Dyzenhaus of the University of Toronto. So let me just give you a brief description of the format for today's event before kicking things off. So we'll begin. In a moment, I'll leave the podium, and Melissa Lane will come here to give her thoughts on the lectures and on the discussion that's followed them. She'll be followed by Professor Dyzenhaus, again via Zoom. And then we'll take a short break of 5 to 10 minutes, and then we'll reconvene to invite Professor Brett to the podium where she will give her responses. And then there will be time, finally, for you in the audience to ask your questions. There hasn't been a whole lot of time. Jay is already on the list. Excellent. I know there hasn't been a whole lot of time for questions this week, but hopefully today we can make up for that. And then we'll wrap things up at 6 o'clock when magically the wall behind me will disappear and there'll be light refreshments on the other side. And so you're all warmly invited to join us for those. So please join me now in welcoming back to the podium Professor Melissa Lane.
Thank you so much, Professor Kolodny, and I would like to once again reiterate thanks to all of the hosts and organizers of these lectures and these wonderful events accompanying them, to the Chancellor, Professor Wallace, and all the members of the Tanner Committee, other faculty who have individually and collectively been hosting us this week, in particular Jane Fink for the terrific organization, and of course David Dyzenhaus and Annabel Brett for the honor and pleasure of joining with them in thinking about these incredibly important topics. So, as I did not comment on yesterday's lecture, I wanted to begin by mentioning a little bit of what I thought was most impressive and interesting in it. So I was especially struck by the phrase active subjection, which marked the ways that indigenous agents in imperially dominated Mexico and Peru engaged in imperial co-productions in shaping their history. And I think more broadly illustrating and capturing the subject's eye viewpoint that Professor Brett has identified, in which the subjects of law are able, through their recalcitrance or temporizing, to shape the contours of their freedom in relation to morally impossible laws, at least to some negotiable extent. And so I thought that my comments on agency that I made after the first lecture on Tuesday were actually accommodated to a considerable extent by an observation that Professor Brett made yesterday, and I quote, "As an active subjection, it, moral possibility, is a form of positive political action, an invitation to deliberate." But conversely, I was also sobered in hearing yesterday's lecture and previously in reading it by Professor Brett's trenchant mapping of how the idea of moral possibility can be and has been abused in political life. So her illustration of this point ranged from the asymmetrical action of a putatively wise legislator, and here I'm quoting, as you can see from the handout, who is indifferent to the moral impossibility that she imposes on her subject. Sorry, not handout, slides. I'm so used to always having handouts. So she spoke about that. She spoke about the asymmetrical ways in which class-ridden democratic factions seek to manipulate moral impossibility so that it falls on others, not on themselves. And she spoke about the creation of false pasts, either by a ruler or by a people, which only leads, as she put it, to a hypocrisy in the present that blocks any passable channel between the possibility that is behind us and the possibility that lies ahead. And I think that remark on the creation of false pasts is especially important at this moment. And finally, she remarked on, not on the slide, on the horrors hidden by Juan de Acosta's remark that it is not to be wondered at, as he put it, if sometimes the iron squeezes the clay a little, talking about the exploitation and domination of indigenous people in Peru. And that made me think of the important title of an unpublished essay by Hannah Arendt, which is that with reference to the idea, which is often said about political life, that to make an omelet, one must break eggs, Arendt titled an essay, "The Eggs Speak Up." So that reminded me, the Acosta, of course, conversely, not listening to the eggs, as it were. So given all those ways in which the handling of moral possibility and impossibility can go wrong, I want to focus my comments today on the political implications of the discussion, and especially on their normative implications, so the normative dimensions of the political sort of lessons that we might draw. So again, I'm going to divide my comments into two halves. So the first half will focus on the standpoint of the lawgiver or the legislator, I use those terms interchangeably, who must exercise what Lon Fuller called legality as a practical art. And I'll think about both coordination mechanisms and persuasion. And then in the second half, I want to return to the subject's eye viewpoint and ask about the normative constraints that might also apply to subjects and their responses to moral impossibility. So let me just start by reminding you of where I ended my comments on Tuesday with this passage from Plutarch's Life of Lycurgus. And again, what I want to emphasize there is that Lycurgus saw that a kind of frontal legislative attack on movable property, the possession of property and wealth in Sparta, wouldn't work. The people couldn't bear it, moral impossibility. But instead, he took another course, and he used what Plutarch calls political devices. And what's interesting about that is, for example, he withdrew gold and silver money from currency, and he ordained the use of iron only. And what's interesting about that is that just doing that, just changing the standards and type of the currency, would have had a kind of immediate effect of changing what would have previously been deeply ingrained habits and customs. Suddenly, there's no reason to covet gold and silver. Instead, now, the only currency that you can exchange is iron. So as I suggested on Tuesday, political devices in this way transformed the landscape of moral possibility. And I was struck yesterday in Professor Brett's conclusion that she titled the conclusion of her lecture yesterday, "Creating Possibility." So I think that's very much in the spirit of what I was discussing here. Now, what precisely empowered Lycurgus to do that kind of radical legal and institutional intervention is another story. And it was so radical that it's probably not a model for most, perhaps any societies. And of course, many of the aspects of his legislation were also very disturbing. But I do think that we do know in political life of a range of approaches by which laws might, in a wider range of cases, seek to intervene to reshape customs or mores, and so redraw the boundaries of moral possibility. And so again, I want to talk in the first half about two such mechanisms, coordination mechanisms and persuasion. And I want to kind of look at both how they work and the normative constraints that might apply to using them for this purpose. So first of all, the first mechanism would be coordination devices, by which I mean the establishment of a new equilibrium point in cases where existing customs or laws are directed to solving some kind of coordination problem. Now, this is, of course, not at all an original point to me. It's been argued significantly. The Mackey should have really been on the left because it's earlier than the Appia, and Appia cites it. But both of these works have been among works that have kind of highlighted this problem. And indeed, the Lycurgan device of changing the currency is an example of this as well. By fiat, there's a new currency, and now everybody converges on that equilibrium, and that sort of immediately and rather easily, surprisingly in some ways, changes makes possible things that might have been impossible before, like no longer coveting gold and silver. So both Mackey and Appia discuss the customs of female foot binding or male dueling, which seemed as deeply ingrained and recalcitrant to change as any case of moral impossibility might be in different historical societies. And yet they proved amenable in various societies to surprisingly rapid overturning. So the law was able, well, I'll say something more. It's not just the law, but law played a role in establishing these new equilibria. Now, it's not just the law, and I'll just quote Appia for these purposes. So Appia emphasizes two other dimensions to this, and I don't have slides for this, so you'll just have to listen. So first of all, he emphasizes that it starts with voluntary efforts and voluntary groups. And in particular, he's talking about the example of foot binding. This was the custom of binding women's feet in China historically. He says, what finally brought it to an end in a society, and this is Appia, in a society in which pretty much all marriages were arranged, there was a very good reason not to give up foot binding your daughters until there were men ready to marry them. So the genius of the strategy of the anti-foot binding societies was that it responded precisely to this difficulty. So he says it was a double compact. You refrain from binding your daughter's feet and you refrain from marrying your sons to foot-bound women. And once now there's a route for people to kind of now start to converge on this new equilibrium while still achieving the goods that they had wanted, namely sort of making good marriages for their children, then that equilibrium, which begins with these voluntary groups, eventually is established by law. Now, Appia, as you can see from his title, also appealed to a further mechanism to explain why people were willing to start adopting this new equilibrium. And this is an appeal to honor. So he says, you know, it's actually because these sorts of practices, foot binding, and also he says elsewhere in the book, dueling, are embedded in a system of status. And so you need to change people's conception of honor in order to get them to change their ideas. Now, remember that on Tuesday, I remarked on Rousseau's praising of a tribunal in 18th century France that was precisely established to change public opinions about duels. And Rousseau emphasizes there that no force, or even, he says, really law, could do that by itself. So in an interesting way here, you might think, well, this is sort of going against what I was saying about Lycurgus, because law isn't doing the first step, or maybe even perhaps the most important steps in getting those changes of norms off the ground. But actually, when you look at Lycurgus and even Solon, a lot of what they do, as it's described in our historical sources, is not in fact passing laws. They do pass laws, but a lot of what they also do is establish new institutions, change mechanisms of behavior through these other means. So I sort of want to wrap this into the idea of what law can do. Perhaps not law, but institutions and norms sort of can be in a symbiotic relationship, and law may also play a role in that as well. So that's the first thing that I wanted to say, is that in these kinds of cases, and particularly these sort of coordination problems where everybody is kind of stuck in this old suboptimal equilibrium, but they need to have a way to get to the new equilibrium together, I think that we can see actually quite quick reshapings, radical and rapid reshaping of the terrain of moral possibility. And so the legislator's viewpoint has that arrow, as it were, in relation to moral possibility in its quiver. So that brings me to a more general account, which is the second overall mechanism that I want to just look at briefly, which is another mechanism of intervention that can be used by law or alongside law, perhaps by lawgivers, even without law. And this is the idea of persuasion. So in other words, simply trying to persuade people of reasons, or perhaps in a kind of, imagistic way, making it plausible to them that they might change their mores. That in itself could also reshape the domain of moral possibility and the contours, as I put it on Tuesday. So this goes back at least to Plato's advocacy in the dialogue The Laws, that a persuasive preamble should be affixed to each legal command. And the idea of that is that subjects, through understanding the purpose of the law and its reasons, will start to follow the law, perhaps without really attending to the fact that the law also is threatening through force to punish those who break it. So my colleague, the scholar Andre Laux, has put it that this is sort of trying to reduce the role of force or coercion in law, but you can still change people's behaviors through deploying this kind of persuasion. Now, there's actually an interesting contrast within the life of Solon that Plutarch draws between Lycurgus and Solon, where he says there actually Lycurgus used more force, but Solon was sort of limited more to persuasion, to kind of soft power, as Bob Cohane would put it. And so, I mean, I think just within the domain of the Plutarch, we sort of see that this question about the mechanisms by which these different lawgivers acted was already on the table. I think Lycurgus uses persuasion too, but there's this kind of set piece discussion in Plutarch which contrasts them in this way. And so to conclude this first half of my comments, I wanted to ask Professor Brett to say more about how far she thinks that persuasion can be used by lawgivers to reshape the terrain of moral possibility. And in particular, we might think about those cases of ratcheting up, which Johann Frick asked about yesterday at the end of yesterday's lecture. To what extent might subjects be persuaded to rise to a slightly higher level of legislatively mandated endeavor in cases of war or plague, or even in cases that fall short of that? Okay, so that brings me to the second half of my comments, actually, I think slightly briefer, which are about the subject's eye viewpoint. So let me just remind you, this is actually a quote from the written lecture, but I kind of arranged it in this beautiful hourglass shape. So let me just remind you of this quote, and this is from Professor Brett in the second lecture. And she says, the people have the right, this is the sort of end of the first half of the first part of the hourglass, they have the right not to obey the law in a slavish way. And in those circumstances, Suarez allowed individuals to look around at their neighbors to see whether they were obeying the law. And then she concluded, and this is the bit I'm really interested in, so I underlined it, if the majority of the community fails to obey the law, it does not oblige the minority. So what you are really finding out, qua subject, is whether you're in the majority or not. Now, in the flow of the paragraph, those sentences apply only to laws that are too hard. But I think that they pose a striking challenge to political theory more generally. Is it the case that laws no longer oblige the minority if the majority has given up obeying them? And how does the terrain of moral possibility and impossibility relate to the reshaping of majorities that is the basic task of democratic politics? Now, as it happens, this is something that I have thought about in the past in a debate with Richard Tuck about the relationship between rationality and moral obligation. So Tuck argued that in a case like, without going through his whole theory, this is based on his book, the title of which is now escaping me, Free Riding, thank you, yes. He argued that, for example, in a case of individual reduction of carbon emissions, if I have no reason to expect that others are taking enough actions in similar actions in enough numbers to make us collectively a real means to an outcome, then I don't have any moral obligation myself to contribute to that because it's not going to be an outcome. But my critique of Tuck was to say, well, for example, in the case of climate change emissions, how do we know how others are going to act? This is especially a case where we're transitioning from climate change being a minority concern to being part of a mainstream movement. And this is, I think, very relevant to yesterday's lecture about times of change. How do we know when mores and customs are changing? How do we know if we're in the minority or the majority? Can we really take that for granted? And I have argued in that context that in fact, I may have a moral obligation, at least in some cases, to do my part, kind of as part of trying to make it the case that enough other people are also going to do theirs. Now, there's a lot of, issues there about the rationality of doing that and costs and so on, but I just want to put this majority-minority question on the table that I don't think that's a distinction that politically or ethically we can take for granted and sort of take as given. And so I want to ask here, for example, what are the normative duties on the citizens of a, say, democracy in this case? Is it enough just to point to something being too difficult? Or do we have a duty to act so as to make it less difficult for ourselves and for others to act, and so make it more likely that the majority will actually act? And I do think there's an interesting problem about fairness here, which also relates to Professor Frick's question yesterday. But I know that I'm moving towards the end, so I had another example, but I'm just going to skip that. But that is the same point. And so I want to then conclude by turning to the permissibility for subjects to flout laws with which they cannot morally or physiologically comply. And here I want to come to the discussion yesterday in the lecture of Hobbes in chapter 21 of Leviathan on the role of fear. So the left-hand column is sort of me summarizing what I just said, and now I'm talking about the timorous soldier, and Hobbes specifies that it's a non-volunteer soldier. So just to remind you, Professor Brett said yesterday she glossed Hobbes's account of the true liberty of a subject here as referring to, in his words, a dangerous or dishonorable office, and she emphasized the dishonorableness in that case, which again, interestingly, intersects with the discussion of honor in the Appia. But of course, also, as she knows much better than I do, as a scholar of Hobbes, which I am not, Hobbes is also talking about the dangerous case, the soldier who is so timorous as to run away under fire. And as Professor Brett pointed out, in this case, it's only unjust to do that if doing so, my doing so as the timorous soldier, would undermine the end of the Commonwealth. And so this is what she called legislating up. If everyone is genuinely needed to save the Commonwealth, then no one is normatively permitted to run away, however timorous they might be. But again, I wanted to kind of ask, well, what do we say normatively about people in that situation who still actually just can't comply? They just are too timorous to do it, even if it turns out that it's actually their obligation. And again, I noticed an interesting discussion of this in Mably. This is, again, this 18th century text. It's influential on Rousseau. And he actually gives an example of this very much in the space of moral impossibility, where he says it would be a strange sort of legislator to think that all you have to do is make laws and men would obey them as a matter of course. And then he gives this actually quite sort of chauvinistic and macho sexist example, but he's talking about an ancient society, Sybaris. So suppose that Sybaris were to proclaim ordering every citizen to have such a stock of courage as to die on the spot in battle rather than give ground. And then I didn't want to put it here, but what he goes on to say is the Sybarites are too effeminate. I'm afraid that's what he says, very objectionably, to comply with this kind of thing. So the law is still going to have no effect. So I wanted to sort of just explore that space. Like, what happens if normatively we are obliged to resist on behalf of the Commonwealth, but maybe even all of us in this case just can't? Like, what should we think about that kind of situation? So what do we do in a case where legislating up is normatively warranted, but it still remains beyond the powers of most citizens? And to link it to the climate change discussion, what normatively should an individual, unusually courageous Sybarite do in that case? You have the one courageous Sybarite and everybody else is too timorous. What should they do? Okay, so let me conclude then. I wanted to come back to the theme of time, which was central especially to the second lecture, but also throughout, because these lectures have offered moving and insightful reflections on how moral possibility depends on the past as well as the future, and in ways that can be either energizing or undermining of normative respect and political change. And so I just wanted to close with some thoughts from Gerald Postema's reflections on time, normativity, and the common law, which bring out the role of agency in how laws evolve over time. And so I was just very struck by these sentences, which I was reading in another context, where Postuma remarks, only time can tell whether a rule becomes a law, which seemed to me very much in keeping. If it's just morally impossible, it just won't or can't become a law. And he spells that out in terms of common use, either through continual use, they will become a law, or they lose their status as valid legal standards. And then I wanted to end with this because I think it links to Professor Dyzenhaus's comments on Fuller yesterday, that Postuma remarks, talking about the common law, that this is a shift in the basis of validity from formal to substantive acceptance of the rules. And I thought that this was quite interesting, that just as Fuller's procedural incorporation of the Thomist conditions of law didn't make them solely formal, as Professor Brett remarked yesterday, but incorporated substance, so this common law perspective on acceptance makes a tacit incorporation of what over time we together find morally and so legally possible. And so I think that we all owe a debt of gratitude to Professor Brett for having so brilliantly illuminated this common legal and human predicament. Thank you.
Okay, we'll now hear from Professor Dyzenhaus.
I presume you can see my slides, so I'm going to get going. So first of all, let me repeat Melissa Lane's thanks to everyone. This has been a great 3 days, even though I couldn't be there for the informal sessions out of the lectures. And I really mean this sincerely. I've been working on similar issues for a long, long time, and I have a real sense of excitement from reading and then listening to Professor Brett's lectures and also Professor Lane's comments on those lectures. I think these lectures can breathe new life into philosophy of law and into philosophy of law understood as a branch of political philosophy. Melissa Lane closed with some quotations from one of the best philosophers of law around, and that is Gerald Postuma, and from his great book, Bentham and the Common Law Tradition. And just as an observation, that book, which I really do think is a great book, has had almost no impact on debates in philosophy of law. And I think that's quite interesting because it's an historical treatment of these problems, and that kind of history is generally neglected in philosophy of law. So what I want to do today is to go back to the first lecture and to the beginning of the first lecture and to try to trace some links between the conditions of law, without which law is not properly law, which Professor Brett attributes to Aquinas, and then later on in that lecture, her conception of citizens' rights as primarily rights against the law rather than against their governors, and that she calls a broadly Hobbesian thought. Now, Aquinas's gloss is on this quotation from St. Isidore, which also comes from the beginning of the lecture. A law shall be honest, just, possible, according to nature, according to the custom of the country, appropriate to time and place, necessary, useful, also clear, so that it does not contain anything that might tend to trick through obscurity, written to no private advantage, but for the common profit of the citizens. That gives rise to the possibility condition, which is quite complex. It's subjective, what is morally possible for this person, but this person is also someone whose sense of possibility is formed in large part by the customs of the place. Quoting from Professor Brett, the habitual collective behavior of a plurality, which it is impossible for an individual to go against. As a result, effective lawmaking requires legislating down. Law legislates down to the level of virtue that is possible for most people. And Aquinas' question is whether custom can itself make law without the consent of the ruler. And his answer is yes, it depends on the constitution. And Professor Brett says that as a result, the possibility condition in Aquinas is a serious break on what can humanly be legislated. Standardly, two conditions are seen as essential for human law in his thought. First, that it be in accordance with natural law, and second, that it be for the common good. What we can see now, however, is that the possibility condition is a critical interface between the moral content of natural law and the common good that is secured by the ruler. It is a space of negotiation between the characteristics of the ruled and the will of the legislator, with agency on both sides. And I want to focus on the intriguing idea of the break. We know that it's partly practical or empirical, but also moral, though what is morally possible is significantly contingent on time and place. And I'm interested now in exploring an idea that is at best implicit in Professor Brett's idea of the break, and this comes from Fuller's claim that compliance with his 8 principles of legality gives rise to an inner morality of law that will maintain a relationship of reciprocity between ruler and ruled, such that the dignity of subjects as responsible agents is preserved. In Fuller's view, at least as I understand Fuller, because the inner morality is intrinsic to legal government, there is an internal legal break. It is not a break that comes solely from a law bumping up against the external morality or the mores or customs of the people, what the people will accept. Rather, it comes out of the way in which legal order structures what we just saw Professor Brett call the space of negotiation between the characteristics of the ruled and the will of the legislator, with agency on both sides, something that Melissa Lane emphasized at the beginning of her comments. I think it's safe to say that what was morally possible in St. Isidore's time, 560 to 636, or Aquinas' 1225 to 1274, is significantly different from ours. Consider a ruler who wishes to impose theocratic rule on a profoundly secular and pluralistic 21st century society. For example, a very controversial interpretation of what Catholicism requires, one that is wrongly styled conservative since it is closer to extreme right-wing ideology. It is an ideology that is integralist in that it seeks to integrate the whole of society into a life of religious virtue in the service of the common good as understood by that ideology. Moreover, that ruler has an understanding of the rule of law and constitutionalism, which his constitutional theorists claim to be that of a classical natural law tradition in which Aquinas looms large. However, these constitutional theorists, those who are advising the ruler, must take some heed of the fact that modern constitutional orders are very different from those in which Aquinas and Isidore lived. So they look to the theories of 2 German fascist political and legal theorists, Carl Schmitt and Eric Fergelin, to support the claim that the ruler is the guardian of the Constitution, that is, gets to decide on the legitimate limits of his authority in order that he might promulgate the common good. This example is, of course, in a way close to home, that is, to the place where you are, since in the US we can give both the ruler and his constitutional advisor a name, Vice President J.D. Vance and Harvard lawyer Adrian Vermeule, as we can name the theory, common good constitutionalism, a theory which has as its heart the unitary executive, President Trump as the guardian of the Constitution. I mentioned yesterday, as one of my reasons for fearing the US border, and therefore why I'm not in the room with you, was that I was giving a talk at Columbia Law with the title, The War Against Law. And that is because I was talking about the last chapter in a draft of a book with that title, The War Against Law. It focuses on just the issues that I've talked about, though in the context of the United Kingdom, where John Finnis, the Oxford Professor of Law and prominent exponent of new natural law theory, has been the main intellectual force in a similar movement in that country. I've put some question marks next to John Finnis's name because I think he fits uneasily into this integralist picture. And I think the reasons that he fits uneasily into the integralist picture may have something to do with remarks that Professor Brett made yesterday about the correct way to understand the theological tradition in which Aquinas worked. So moving on, I want to mention that Finnis does make a brief appearance in Professor Brett's lecture. And that is because Finnis, at the end of an article, does say that Fuller takes his list of legislative principles directly from Aquinas, which is something that Finnis acknowledges. But I'm quite interested in finding out more about the substantive natural law tradition in which those principles were located, according to Aquinas, and why it was that he provided an account of the principles, which then could be extracted from that tradition, as Fuller tried to do. Now, I want to move forward a little bit in time in order to say something about Hobbes. So moving forward from the quotation from Isidore to Leviathan in 1651, chapter 30 of the Office of the Sovereign Representative. And here, Hobbes says something that actually sounds quite similar to what we saw Isidore say. He says, "To the care of the sovereign belongeth the making of good laws. A good law is that which is needful for the good of the people, and withal perspicuous. For the use of laws, which are but rules authorized, is not to bind the people from all voluntary actions, but to direct and keep them in such a motion as not to hurt themselves by their own impetuous desires, rashness, or indiscretion, as hedges are set, not to stop travelers, but to keep them in the way." And in saying that, Hobbes follows through on the opening paragraph of this chapter, in which he states, "The office of the sovereign, be it a monarch or an assembly, consisteth in the end for which he was trusted with the sovereign power, namely the procuration of the safety of the people, to which he is obliged by the law of nature, and to render an account thereof to God, the author of that law, and to none but him. But by safety here is not meant a bare preservation, but also all other contentments of life, which every man by lawful industry, without danger or hurt, to the commonwealth, shall acquire to himself." I want to draw attention to several important differences between Isidore and Hobbes, the first two of which are apparent in these quotations. First, Isidore names justice as one of the qualities of the law. Hobbes does not on the surface disagree, but only because for him to say that a law is good is not to say that it is just. That is because, as he says here, no law can be unjust. The law is made by the sovereign power, and all that is done by such power is warranted and owned by every one of the people, and that which every man will have so no man can say is unjust. It is in the laws of the Commonwealth, as in the laws of gaming, whatever the gamesters all agree on is injustice to none of them. So I think the first difference between Hobbes and Isidore is that Isidore seems to equate the goodness of laws with justice, whereas for Hobbes, while all laws have the quality of justice, they need not be good. In addition, Hobbes quite clearly supposes that the sovereign may make a law that is not according to nature, despite his claim that the sovereign is obliged by the law of nature to make good laws. He claims, as he does elsewhere in Leviathan, that there's no tension here, because the sovereign's accountability for infractions of the laws of nature is to God alone, not to his subjects. The second difference, I think, is that Isidore and Hobbes would surely have disagreed on the question of the content of the common good, a term which is ubiquitous now in political and legal theory, in no small part due to Vermeulen and Finnis. Professor Brett refers to this idea several times in her lectures, and she does not elaborate here much of the content Isidore and other theologians gave to it, but it seems that it is intrinsically connected to a Catholic doctrine of the virtues. And we saw that one of the main problems the theologians addressed is how to use the law as an instrument of natural law and virtue, while taking into account what is possible to demand of the ordinary folk subject to the law in all the texture of their society and lives. For Professor Brett, that is the problem of possibility, and it has both an empirical and a moral dimension. It is empirical because the legislature must take heed of the people as they in fact are, and it is moral in that given how they are, the lawgiver should not require of them what is morally difficult, let alone impossible. The break on legislating down does not, however, mean that the ruler cannot demand more than would usually be considered morally possible in times of crisis, though even there one finds a limit, largely imposed by time. Hobbes, I think, has a very different idea of the common good, captured dramatically in C.B. Macpherson's label of possessive individualism, as we saw in the earlier slide from his reference to all the contentments of life, which every man by lawful industry without danger or hurt to the commonwealth shall acquire to himself, as well as in his image of the law as hedges. And there is an echo of this image of the law as hedges later in Fuller. Fuller says that the law provides guideposts for human interaction. And also, as I tried to show yesterday in one of my slides, he has a highly individualistic view of the person, implicit, as he puts it, in legal morality. There is a third difference in that Hobbes and Fuller are also alike, in that Hobbes's extensive list of the laws of nature are much more procedural and formal than substantive. And here I want to qualify the way I put things yesterday, partly in response to Professor Brett, when I contrasted too sharply the procedural with the substantive. When Fuller titled his last chapter The Substantive Aims of Law, he was suggesting that there are substantive implications to the principles of legality that make up the inner morality of law. So the contrast is better put by saying that it is between substantive laws of nature, as one finds perhaps in a caricature of Catholic theology, and procedural principles that have substantive implications. And there is, I think, also, and we talked a little bit about this yesterday, an institutional difference. And we can consider here, for example, Hobbes's discussion of the laws of nature that apply to arbitration and hence to the sovereign as the ultimate judge. And these laws appear at the bottom of the slide. Law 11 is the law of equity, that if a man be trusted to judge between man and man, it is a precept of the law of nature that he deal equally between them. And because every man is presumed to do all things in order to serve his own benefit, no man is a fit arbitrator in his own cause, which gives us law 17. For the same reason, law 18 holds that no individual is to be judged who has in him a natural cause of partiality, and law 19 is that in controversies of fact, the judges must give credit to the witnesses. And I think what we get here is quite a rich understanding, a procedural understanding of the laws of nature. And these laws are both procedural and substantive in their effect without determining the content of any decision by an arbitrator who is faithful to the moral discipline of its role. Moreover, when the parties submit a dispute to an arbitrator, they do so not only in the expectation that it will give a decision which provides a definitive resolution to the dispute, but so permit them to avoid fighting it out by whatever means they choose. They also submit in the expectation that the decision will accord with the laws of nature, which set out what we might think of as the moral discipline of the arbitrator's role. It is the case that if a sovereign violates one of these laws, subjects are precluded from complaining, but it is also the case that in any somewhat complex society, the relationship between sovereign and subject will be mediated by subordinate judges and other officials. The subject is entitled to challenge an official on the basis that they acted without lawful authority, and a judge who hears the matter must, in interpreting the law, assume that the sovereign intended the law to comply with the laws of nature. And that creates an accountability relationship between sovereign and subject that comes about through the duty judges owe to the sovereign, not duties owed by the sovereign to subjects. And we saw in the slide yesterday of Fuller's picture of the rule of law, what appears in slightly different form before you now. So you'll recall, I hope, the slide from yesterday, and we have a very similar slide today on a picture on the right-hand side of the slide, or at least on my right. And here on the left, we have the cover of a book, my first book, which Chris Coutts mentioned yesterday, Hard Cases in Wicked Legal Systems. And I like this cover, not only because it's a cover of my book, but because it does give you a vivid picture of an apartheid law. And in this picture, you can see a little black kid trying to climb up a sign, and the sign says at the top, as you can see, whites only. That's the Group Areas Act, which operated in South Africa from the 1950s until the end of apartheid. And the Group Areas Act divided South Africa into different residential areas for different racial groups. Of course, the best residential areas were given to the white minority, and it made it a crime for a person from one racial group to reside in an area set aside for another. But I have claimed in my work that this apartheid state, this highly discriminatory state, was still a legal state. And what I attempt to do on the other side of the slide is to provide you with a picture of the apartheid state. And what we find in the apartheid state is we have the framework of law around the whole state. We have the sovereign supreme parliament making laws, all the subjects are subject to the same general principles, the same general norms, that is both the black majority and the white minority. But the way that the apartheid state worked is that statutes were enacted that carved out vast exceptions to these general norms. And the black majority were placed in the spaces where they were discriminated against and oppressed. But they had, as I put it in my work, second-class status as citizens. They had 1 foot in the first-class space and 1 foot in the second-class space. And that meant that there was work that lawyers could do in order to challenge the apartheid laws. That is, they could bring a challenge to the way the laws were implemented by going to an official and a judge and asking whether the way that the residential areas have been carved up was reasonable, respected norms of equality, norms of non-discrimination, and so on. And they could do that despite the fact that there was no written constitution which gave judges the right to test the validity of statutes. So what one gets there is an ability of the subject to challenge the implementation of the law, to challenge the law in terms of Professor Brett's terms of what is morally possible for the subject to do. And that does give the black majority, even during apartheid, a kind of citizenship, in that they have a kind of agency which they can attempt to vindicate in going to court. There was also in the apartheid state something that I call a prerogative space. What was a prerogative space? When it came to opposition to apartheid was governed by very draconian laws, including the security laws that allowed officials eventually to detain people who were considered to be threats to national security indefinitely on the mere say-so of the official. But the prerogative space, the space in which there was, in a way, no law, was still a space that was bounded by law, and that allowed lawyers to bring challenges to the way that the security laws were implemented. And that, too, made a difference during the apartheid era. And so what I think one finds here is the way in which the Fullerian framework, even though it's horribly distorted in the apartheid state, still does provide a kind of agency to subjects. And that agency comes about through the institutional apparatus that makes it possible for subjects to bring challenges to the implementation of the laws. And now where I'm going to is a slide that I've actually put together, I confess, while Professor Lane was speaking, when she mentioned the evocative title from Hannah Arendt, The Eggs Speak Up. So this slide is a slide which portrays an Israeli human rights lawyer, Michael Sward, who does most of his work in the occupied territories. And you see on the one side of the slide, Michael Sward standing against the wall that divides the occupied territories from Israel. And Sward has written a book, The Wall and the Gate, about his practice in the occupied territories, which I think is a fascinating study of the way that lawyers can try to make the law less morally impossible for those who are subject to both oppression and discrimination. Sward, and I recounted this to Chris Coots's class yesterday, presents his human rights practice in terms of an agonizing dilemma, in that he constantly has to wrestle with the fact that he's legitimizing the very regime that he struggled against by participating in courtroom battles, because that, in a way, acknowledges the authority of the state. But as part of his justification for doing this, he speaks about his clients in the following way, and that's on the left-hand side of the slide. So talking about his Palestinian clients in the occupied territories, he says the authorities ignore them, sometimes not even responding to their communications, batting them away like bothersome flies until they file a petition. As soon as the clients hire legal representation, and enter the legal process, they gain heft and volume and visibility. And whatever one makes of this claim in the context in which it's made, I think it does tell one something interesting that might be perhaps different from the context in which both Isidore and Aquinas were operating. Because it's not clear to me that in that context, there was this kind of institutional apparatus available that made it possible for subjects, even discriminated against subjects, oppressed subjects, to assert some kind of agency other than by engaging in acts of illegal resistance. And it's fascinating to me, again, coming out of Professor Brett's comments yesterday, why it was the case that perhaps most prominently Aquinas sought to develop an account of legality that was at least at some distance from what we might think of as their substantive theological commitments. Why was it the case? Did that have to do with a sense that even in a society that was at least religiously homogeneous, it was important to ensure that the laws were not implemented in a way that made it morally impossible for subjects to obey them? Is that why they developed an account of legality that many centuries later Fuller could pick up on and turn into his completely secular account of the inner morality of law? So I think that's where I'm going to end. I've gone slightly off script, at least from the script that I sent to Professors Lane and Brett, and I apologize for that. But I did want to pick up on some remarks that she made yesterday and also on some of Melissa Lane's discussion tonight. So thank you very much.
So we'll now take a brief break, and let's reconvene at 10 past the hour. So please join me in welcoming once again to the podium Professor Annabel Brett.
Well, thank you very much. And together with Professor Lane, I'd like to reiterate my thanks to everybody involved in this process, including you all for coming along for a really astonishingly creative and thought-provoking few days. And I'm really honored and humbled that this work on this apparently extremely obscure concept does have the ability to make us think about commitments in the present, and to have had that elucidated by two such wonderful and distinguished scholars as Professor Lane and Professor Dyzenhaus. Again, that's just been extremely special for me. Okay, so I'm going to try and keep this brief because, as you know, it's people need a chance to ask questions. What I've taken away from this in terms of thinking about these overall lectures and project, that first of all, that there is something moral possibility for all its kind of ambiguity and indefinite contours and unclear relation to other kinds of possibility. Is a kind of usable or workable notion. It's something that we can actually understand, and we can use it to think about a certain kind of oppression or domination that certain people feel in different contexts. So that is encouraging in itself. And also this idea of this possibility gap that I identified in Suarez and then was just extremely excited to find in Fuller as well. That and calling it a sort of antinomy, that there is this sort of gap between law from the point of view of legislated and the law as obeyed, that possibility distinctively opens up. and that this gap in a certain way can't be closed, and it can arise in any kind of legal system. And even in a democracy, it's not closed simply by the fact that you consent to legislation, because even a law that you consent to, so in a way the subject of the law becomes the legislator, which might seem to close that gap, actually doesn't, because even if you consented, at some later time it might be impossible for you. And therefore, in parallel, the idea that some kind of recognition that that gap exists, or at least some potentiality to act within that gap, either by oneself or through mediators, is part of what makes the difference between a dominative or tyrannical form of government and one that is not. Okay, so the point that Professor Dyzenhaus made yesterday and again today about the mediating agents within that gap, the fact that we're not talking purely in terms of sovereign and subject, and it's something that Professor Lane also talked about just now. There's a kind of institutional texture there, and when we're thinking about possibility, that's really, really key, and that's a central message that I take from these two sets of comments. So talking with Professor Kutz yesterday at dinner, I felt I should have underlined a little bit more that the questions of possibility arise in these 16th and 17th century theorists in the context of obligation and the casuistry of obligation, with which these centuries are distinctively obsessed, partly because they're questions of allegiance. Right? Am I obliged to obey this law? And that kind of framing takes you back immediately to the author and therefore the authority of that law that it has over you. And the obligation to obey God's law is the paradigm of obligation. So from that point of view, you do get this sort of binary relationship between sovereign legislator and subject and that particular interface. But in a modern state, and actually just in the ancient state, and in any state, in the early modern state too, it's not the case that that's all you have. So that is that extremely important point. There's this apparatus of administering law in between. And the figures of the judge and lawyers and various other officials occupy that mediating space. And it's very interesting, apropos of what we've just heard about law in an unjust state, even in an apartheid state. So Juan de Matienzo, that we met yesterday in the Gobierno del Peru, he himself was a judge, an oidor, and I've also looked at Vasco de Quiroga in Mexico. And they are really interested in courts and the sort of procedural aspect of justice. They recognize that the, quote, Indians are devoid of legal means. So, you know, they're not in a position to bring a complaint to court. So even if they are oppressed by X, Y, or Z, there's nothing we can do about it. So part of what they're trying to do is think about how can we create an institutional context in which they can bring complaints to court. And both of them conclude that you can't do that without totally changing the polity. That for them to have that power, they cannot continue to live in the way that they do. They have to be brought into a different kind of republic. So, I mean, that to that extent, it underlines what I want to say about the politicality of possibility. But it's a very important point. So I was thinking about this mediated relationship in early modern political thought, and the figure of the judge stands in that sort of space. But so, for example, does the figure of the inferior magistrate in resistance theory. I'm sure you're all familiar with this, but classically in Huguenot resistance theory, you have a distinction between the king or the crown and the kingdom, and a distinction between officers of the king, the sort of royal officials, and officers of the kingdom who act for the kingdom as distinct from the crown. And these officers are inferior magistrates and empowered to resist tyranny, whereas the subject people is not. So I wanted to bring in Grotius here. I mean, he's been a presence sort of in the background to what I've been saying, but I wanted to bring him along. So Book 1, Chapter 4 of the Law of War and Peace, first published in 1625, is on resistance. And here Grotius systematically rubbishes the Huguenot idea of inferior magistrates. So the inferior magistrate is somebody who has a public capacity and can exercise that against the crown. And Grotius says that's ridiculous. Any action against the crown is by definition not public, because the sovereign or the crown defines the public. So these people are private actors, and they are their resistance is in fact rebellion. So that would seem to suggest that there's no kind of space for resistance at all. But here Grotius asks that question that Richard Tuck sort of put his finger on right back in 1979 with natural rights theory, which is, does the law of non-resistance oblige in, as the 18th century translation puts it, the most pressing and certain straits? And the answer is no, it doesn't. Grotius is thinking in terms of the original covenant. We have to interpret the original covenant to exclude that case. So this is a moment when subjects themselves can interpret the law. And his example is the case of the Maccabees, persecuted by Antiochus, who fight back. They fight on the Sabbath, which is their interpretation of God's law, that it actually allows them to do it in that case, and they are right. And they also interpret the political law of non-resistance correctly. Now, all of Grotius's examples here are from Suarez, and they go back to Aquinas, who himself addressed the question of, can subjects interpret the law themselves? And his position, I have to say, is not entirely clear. So I think Grotius was directly addressing this Suarezian question: does the law oblige with danger of death or other grave temporal harm? And that's a possibility question. And it's associated, as in Suarez, with the ability of private subjects to act directly to disobey a law. So I think I want to say that in a possibility, in an early modern possibility frame, if we acknowledge a possibility gap, I think there needs to be a role for subjects in interpreting the law for themselves. So there are mediators in this space, but I think I would want to argue that the possibility of interpretation and acting needs to go down to the level of private subjects themselves. But I've been thinking about this question of institutional texture has also made me think about temporal texture of disobedience. So if you remember Suarez's concern, his concern is with the people who first start to resist the law or to disobey the law, then the others who follow them, then all the rest. So there's a kind of temporality or texture to resisting laws that are thought to be morally impossible. And I think in that texture of time, that's also in a complicated, complex institutional state, that's also a point in which different levels of agency can come in. So, for example, it might be that the judiciary or judges take the role, or the ones who first start, and there's a role for leadership there. So, or lawyers putting a petition. So So I don't think there's a kind of either or there. I do want to argue it goes down to subjects, but I don't think that that excludes. And I think it's really important to think about that agency of mediating officials, figures of various kinds. There's a question about how capacious we want to make our category of moral possibility. So someone like Grotius is slimming it right down to danger of death. Hobbes is slimming it down to danger of death and dishonor. But I think both of them want to contain it. So there is a possibility cap and there's room for disobedience. But if you don't put that much under what's morally impossible, then you reduce that space. Prima facie, I mean, this is why I was talking about the scholastics. I think there's something attractive in expanding the scope of the casuistry beyond immediate danger of death or even dishonor. There are lots of things that might be very painful and a legitimate reason to press pause on obedience that aren't actually death or dishonor. For example, if there was a heavy tax burden, you had to give up your dreams, that's quite hard. So I think it's an attractive aspect of this more expansive casuistry, the morally impossible, that sympathizes with this kind of position. But we then have this danger that various people have alerted to, that, you know, that's so wide. I mean, everyone can just say, well, it's too hard, and you could get a lot of unethical positioning within that claim of the morally impossible. I think that, and this is why I was partly worried about the individualist casuistry. I think if you have kind of a collective judgment that something's too hard, that's some kind of safeguard on this sort of extreme moral latitude, which would make any kind of rule of law sort of impossible. And here is Professor Lane's question about majority. I think that kind of argument only works if relations between, the lateral relations between members of that community are relatively equal, because otherwise you could get questions of majority sort of tyrannizing others and people, a destabilizing situation where good people find their agency thwarted for those reasons. And Suarez himself is aware of that danger with the majority question and hedges it around. Okay, so I think one question that I need to think about is how much can we put under the heading of possibility without straining the rule of law beyond any kind of plausible bounds. We might not want to slim it down as far as Hobbes or Grotius, but we don't want to extend it so that anyone can make a claim in that space and the law would take it seriously. Hobbes and the rule of law and the question of the common good. Well, the common good in all of these sources is a bit vague. It's a kind of mixed bag. You kind of know when a law isn't for the common good. I mean, this is part of the majoritarian argument. If most people aren't obeying it, then it probably isn't for the common good. There's a kind of hermeneutic that's going on there. And even if it's, if you still think it was for the common good, but you'd have to actually coerce people in quite a violent way, then that's probably not for the common good either. I think they want to put under the notion of a common good both sort of substantive goods, so a certain kind of virtuous way of life, but also factors relating to peace and tranquility. How much time do I have? Okay. Sorry, these questions are so rich. I feel that I'll leave Hobbes to the questions. Yeah. Because I do want to. I do want to address Professor Lane's comments and about change and changing customs. So one question that arises from this literature is that there's something sort of prima facie tyrannical about changing the law, right? At least in a sense of profound change. And for this reason, there's this very conservative accent on a lot of early modern possibility thinking. So I really like the idea here of the indirect and the oblique. Again, I think I have a slight worry on the democratic transparency of that. I think changing the currency like that might not work in many contexts. It was very successful for Lycurgus, but people resent things like, they don't seem to have resented it in the particular case, but I think the potentiality for resentment is which would be destructive, is quite large. Yes, but this question about beginning and where change begins, that seems to be a kind of co-agency, and I really like the example of the foot binding, where actually private agents plus the law act together to change a custom. And I'm interested in what I would think of as a kind of allyship. And I need to read more about this context, because I would see those voluntary people who signed up to the pact, the double pact, as a kind of allying. And I think it's a new concept, but it seems to be an important way of thinking about creating possibility in situations of social stress, inequality, and division. And the question about honor is very resonant, as we've been discussing in a possibility context. Can I leave it there? Because I really think we should have space for questions. And I don't feel I've really addressed this, but that's because I was sort of, intercutting. So I will leave things there.
Okay, so we have an opportunity for questions. Hopefully you can step up to the standing mic. So we'll begin with you, Johan. Oh, Jay. Oh, I guess I already said Jay. Yeah, that's right. Jay, you go first.
You always call me. No, Jay, you go first.
Yeah.
Thanks so much, Annabel and David and Melissa for these really rich reflections the last couple of days. I'm really intrigued by this notion of moral possibility and the connection to the subject's point of view, and what you were saying today about how comparing Hobbes and Grotius to other thinkers and who had a more expansive conception maybe of moral impossibility that extends into territory where death and honor are not necessarily at issue. That seems very intriguing to me. And but I just wanted to ask a couple of questions about how we should understand this and how it might be relevant to some of our contemporary notions. Maybe just by way of inviting you to clarify some of the thinking of the figures you're discussing. One thing you were talking about was that we should take seriously the idea that some people might find something too hard, right? And they're finding it too hard seems miles away from necessarily, facing death or dishonor or so on. And I find that really intriguing. And that does, I take it, connect to the subject's point of view. It's a matter of what one finds too hard or would find it too hard if one were asked to do it. And I take it this is also kind of an elastic notion that allows for ratcheting up in times of exigency, if I'm understanding the view. If we're in a plague or a war, people might not any longer find it too hard. And I assume that's because they have some subjective awareness of the exigency that we all face, right? And so they're no longer going to find too hard what they would find too hard under normal circumstances, right? And so we couldn't infer from the fact that they find extreme sacrifice tolerable in times of exigency that that it's morally possible for them to make the same sacrifice in normal times, right? If I'm understanding the view, because what they find too hard or possible is sensitive to their own awareness of what the stakes are, or something like that. That's one way to interpret the view. But I'm curious, if we think about the contemporary circumstances of climate change, just to focus the mind, I think if you ask most carbon taxes would be the economist's way of making a start towards collective action to address this problem. People in democratic cultures like ours find it too hard to, would say that they find it too hard. And yet we're actually in an emergency, right? And people write about it all the time. And so it seems like the sort of situation in which, what's morally possible ought to be, very different from and yet that's not how it actually operates. And so anyway, if there's anything you could say about that would help me to understand the notion. Just one final question, and this connects to a notion that you invoked it a couple of times, where the sense of something's being difficult connects to one's moral sensibility. You talked about people finding it repugnant to be asked to do something or made to do something. I thought that was a particularly interesting subclass of cases, maybe. But of course, it seems from a contemporary perspective, everything depends on why you find something repugnant. I mean, I'm sure in Jim Crow, in the Jim Crow South, people found it repugnant that they would be required to mix with Black Americans in public spaces, for instance. And that doesn't seem like it should constrain law at all. The clearest cases for me are cases where they're going to be more individual cases, but cases of religious conscience. So a pacifist should be allowed to do some other form of public service besides being drafted into the military. And we make accommodations for people whose religious views would make it repugnant for them to do something. Yep. Those cases seem interesting cases where a sense of repugnance does place a constraint on what a just law would look like, at least. Except that in these cases, possibility doesn't seem to have anything to do with it. It seems like what matters is just that we would be making someone do something that goes against their conscience. The fact that it would be hard for them to go against their conscience, is not really the real complaint, it seems like. Or at least that's one thought I had about these cases. I mean, it might be true that it's very hard to do something that you find repugnant for reasons of conscience, but it seems like if it violates your conscience, that is in itself, independently of questions of difficulty or possibility, kind of an objection to kind of coercively making you do it.
Yeah. So those are great questions. So yes, on the too hard and the irreducible subjectivity of that, and also so going now, I can address, Melissa, your points a bit better. So I think I really like the foot binding example because so for example, it'd be really, really hard for a Chinese family not to make a good marriage for their daughter. They don't want to. That would be really hard. So we need something that accommodates the fact that they would find that very hard. And the only way to get around it is by this kind of creating this route. But at that point, the law and institutions are sympathizing with the desire to make a good marriage for their family. And that's exactly the kind of consideration that this scholastic thought is. And that's something that I find really attractive about it. Because you could say, well, why is that so important? Well, that's a stupid question. It obviously is really important in a certain culture in which these are very, salient. But then we do get the question about how far we're going to bend over backwards to cultural predilections and sort of go along with them. So, for example, the example that we saw in ours, the one that they always cite is that aristocrats cannot work in the fields. I mean, no, it's repugnant, and it's sort of, it's just dirty, it's sordid, so they can't be forced to do that. And that's where we would want to say no. But I think, that is a function of historical change, isn't it? And I think it's really important that we are this idea that we've been discussing, that our sense of what's morally impossible in a way that we're prepared to recognize as a claim in law, and the kind of moral impossibility that we're not prepared to respect, I mean, that is going to change over time. And it's that, and we can't think, so there would be contemporary analogues of the not dirtying your hands, but they wouldn't actually be the same thing. And I think it's part of this equilibrium establishing that's been going on. And I think the point about the role of courts in testing that and sort of taking cases and establishing, well, what is it exactly that is, that we're prepared to respect? I think that's really key. And I think that point about the texture of possibility and the texture of agency and the possibility to get was just really key, and from both of my commentators. Yeah. So this question that Melissa raised about, fighting for your country, why isn't that too hard? Well, this is one of the things that I find they're a bit vague about. So Arriaga seems to think it's kind of okay because you don't have to keep it up for very long, right? You can see an end in sight. And I think there's something to that, this is a time of crisis. We face up, but it's like a kind of crunch moment in time. It's not your whole life. If it was your whole life, you would probably despair and give up. Some people emphasize hope, so that the Commonwealth can ask you to fight for it as long as there's hope. But if it's a really hopeless situation, it can no longer ask you to do that, and you're free to go. So they all want this claim. I'm not sure that any of them quite put their finger on why. Except, we go a little bit later with Pufendorf. So Pufendorf is addressing objections from Leibniz, essentially, who says that there must be something transcendent, what Sharon Lloyd calls a transcendent interest in fighting for your country. You've got to believe in God or something, because otherwise why would you do that? And Pufendorf says, no, this can be totally contained within the horizon of natural possibility. The Commonwealth doesn't require everybody to be really brave, but what you have to do is you just make it clear that the penalties for desertion are worse than you're going to face certain death by firing squad. Well, that's my... I was working on this, sort of began in 2018, and it was the centenary of the end of the Great War, and I was really thinking about this and about the kind of coercion that was applied to soldiers who are suffering from trench, shell shock, and were simply shot, and the dishonor that came on their families that is still there. And that's something that Pufendorf, and he says, well, so, it's basically choosing the lesser of two evils, and any sane person, you don't have to be particularly brave, but you're going to do this. And that strikes me as a cynical manipulation of moral possibility that in itself is. So I quite like my theorists who don't have a proper explanation, because at least they don't have that one. But I think, if they, we plug into the way, most of us just aren't in that situation, but people are astonishing in what they can come up with, and I think that is the expectation. And so there is this projection of these, these cyberites who, but I don't think any of them can actually imagine that a community would be like that. There's something about being in a community and the kind of collective solidarity that means that actually people are going to fight. That comes to kind of allying and sort of the fact that you're not alone, that I also think factors into. So there's an interesting example in More's Utopia, because you'd have thought the utopians were terrifically virtuous, but it turns out some of them are quite cowardly. So what do? Well, two solutions. One is that you double them up with someone else, someone brave. The other is you put them in a spot where they can't run away, and they're just going to have to find that virtue. Anyway, there we are. Okay.
Johan?
Thanks to all of you for the great lectures and the wonderful commentaries. So this question builds on Melissa Lane's commentary today. So it's really as much a question for Melissa as it is for Annabel. The question is how to arbitrate the tension between two thoughts. The first thought was at the center of the first half of Melissa's comments today. It's the thought that in applying the possibility condition, it would often be a mistake to overlook the feedback loop that exists from law to moral possibility itself. Right? So whether or not something is morally possible or impossible for citizens of a state is often not independent of whether it's legally mandated. Rather, as Melissa was stressing in her comments, the law can often expand what it's morally possible for the citizens subject to it to do, right? It can do that in several ways. So for example, the law can help us overcome inner resistance. It may be too hard for most of us to voluntarily turn over significant proportions of our income to help the needy in our country, but legally mandated taxation to fund a welfare state, this is something that is morally possible for most of us. The law can also change the strategic situation. So, unilaterally you're disarming in a society where everyone else is armed and dangerous. That is not morally possible. But once the state comes in and coercively enforces a law that requires all of us to lay down our arms, we have a way of overcoming the prisoner's dilemma in this situation. And then, law can also alter the meaning of our actions. To take another of Melissa's examples, in a society that does not legally ban dueling, refusing to duel someone when they've insulted your honor is a sign of cowardice. Once the law makes it legally impermissible to do so, you have a good reason not to duel that is not simply cowardice, right? So to sum up this first thought, right, in applying the possibility condition, it's often a mistake to treat moral possibility as an independent variable, right? It's very much influenced by whether something is the law or not. But at the same time, and that's just the second thought, we don't want to take this point about the feedback loop from law to possibility too far, right? There are many laws that could become morally possible for people to obey if only we made the penalties for breaking them sufficiently severe, right? As came out in your World War I case. So if you execute everyone for cowardice, well then suddenly we've solved the problem of cowardice and we've allowed people to find their courage. Likewise, universal chastity is very difficult, but if you only make the penalties sufficiently severe and dire, suddenly many of us could find it within ourselves to observe such a law, right? So it would clearly void the possibility condition of any sensible content if we imposed no limits on the kind of force that the law can bring to bear on subjects in compelling their compliance. So the question then is, how to bridge the kind of tension between these two thoughts, that on the one hand, in determining whether something counts as morally possible for the citizens, we do want to, bear in mind that, it being a law and a law that comes with, penalties for breaking it can rightly, help determine whether it's morally possible or not. But at the same time, there are limits to that. Any thoughts about that would be very helpful.
Yeah, so I'll just say something briefly and then hand over to Nisla. Yeah, so that's a really great question. And I think, this idea that having a law, but more in Professor Dyzenhaus' term, a rule of law. So that's a distinctive kind of space that actually alters the psychology of the people who live within it. And that is a Hobbesian thought, I think, that the state of nature has a distinctive psychology. It's time of war. The civil state is time of peace, and what law and the rule of law does within that is to create a framework of legitimate expectations. It creates a time. I think Hobbes is a theorist of possibility. I think he's a theorist of time, creating a certain kind of time in which you can confidently expect that you're not going to be attacked either by your fellow citizens or that you're going to be subject to some kind of punishment that you didn't expect. So there's going to be that space opening to you. And the psychology of a person who inhabits that space is very different So I totally agree on the transformative effect, and I think the people that I'm interested in would broadly put that under kind of possible according to custom, because customary framework is still it's this idea that you're not acting in a vacuum, which is extremely stressful. You are there are these kind of frames around you and spaces around you. And it's clear, I mean, let's take Hobbes and de Quille. I mean, he certainly thinks that attaching a penalty is one way of altering your possibility conditions, right? And, he says in de Quille, the purpose of punishment is not to force or something, but to form the will the way the legislator wants it to do. And Pufendorf is being very Hobbesian, and Pufendorf is more of a reader of de Quille than Leviathan, I think. Well, of course, with the Hobbesian sovereign, I mean, there's just no limits to what she can do, except that I do feel that Hobbes, John Locke objects to Hobbes that you cannot have a rule of law with a Hobbesian sovereign. It's incompatible because the sovereign is precisely the person who's going to take away, can intervene at any point, and so that space is voided, and it doesn't exist. I think that Hobbes thinks that it does exist. But I think, it lets the genie out of the bottle a little bit. Once you have something like the rule of law, once you've got the institution of property, you create a psychology and sort of lateral relations, which then do condition what the sovereign can actually do. And I think that, that's the point at which comes these limits on the kind of manipulation you can do. So I think Hobbes on taxation is actually a very interesting subject, because there he does think that some kinds of taxes might be too hard. So he actually buys into possibility language in that more expansive sense, and has to think about a taxation system that will be acceptable across the population. That's as far as I got.
Yeah, great. Is that on? Yeah, okay, great. Thank you. Yeah, I would only add, I think you summed up my point beautifully and very economically in the first point that you made. I hadn't really thought about the problem of the excessive punishments, and just thinking about it now, I think it's interesting. Maybe it's another dimension of ordinary freedom is that you can decide to take certain kinds of punishments or to risk taking certain kinds of punishments. So, I might decide I'm willing to jaywalk. It's important to me to get there on time. Maybe I will be punished with a fine, but, whereas if the fine were execution, but if that were everything, kind of, it would seem like, so that's an interesting dimension of freedom that I hadn't thought about before. I mean, the only thing I would say is I know that can also produce its own pathologies. I love David's phrase from his book title of pathologies of legality. And I know in the climate change space, for example, corporations that just decide to risk paying the penalty of the fine, so that, now maybe it's not strong enough. But so I think even within that side of the dilemma, there are many dilemmas in terms of how you balance those sort of competing sort of desiderata.
Hi, Marianne Constable from Rhetoric. I'm just wondering whether you've thought about jury independence and jury nullification, because I think those are examples of some of the things that people have been talking about the law building within itself some of the limits to the possibility, condition, or constraint. And it's also institutional, coming between the subject and the sovereign, and it also appeals to the custom of the country or other things. So I think that I would like to hear if you've thought about that and its relation. Also, I think Bushell's case, I was trying to look it up really quickly, but my phone wasn't working. I think, isn't it before Hobbes dies? And I wondered if he ever wrote anything about it.
So, not to my knowledge, but it's always a case like this that you then start combing through your knowledge and thinking, right? Yes, so I haven't. So the answer is I haven't, and I think it's actually coming throughout this that I am lamentably ignorant about common law. It's true, and I think that. But there is a kind of translation of the possibility condition into common law, and I would really like time to think about that some more. And I think this question about juries as a particular kind of agency that's on the borderline between being a subject and actually putting your space into that sort of mediation space, I think that's a really, really interesting thought. If we're thinking about the institutional articulation of possibility, if you like. I think that's what we're saying, this very sort of textured, and juries can, I mean, this has been, recently in the case of, the law at the moment in England is coming down very, very hard on climate activists. And punishing, I've forgotten her name, which is shameful, but anyway, she stood outside the courthouse just bearing a sign saying, "Juries, you have the right to acquit according to your conscience," and she was arrested for doing that. But juries can be allies as well, and they can act according to their conscience. So that, I think that's a really interesting point. But no, I haven't thought about it. So thank you.
So in this room of philosophers and lawyers, Annabel, I hope you'll forgive a historian's question. So I love the notion that because the morally impossible is not literally impossible, that the possibility exception opens up a space of popular politics and negotiation. But I wonder if we're not assuming in this conversation a historical context of powerful states in which normally what the state promulgates as law actually happens, and therefore a possibility exception is needed in order to create that space of negotiation. I'm wondering if instead we have an early modern context in which no law is ever more than an opening to negotiation, whether in fact the possibility exception isn't a way of closing down that space of negotiation, because it's taking that space, it's appropriating that space of negotiation into a world of law where religious theorists, lawyers, politicians get to decide under what conditions there is in fact a moral possibility for a resistance that is the normal mode of politics in this, in this era before the regulatory state.
Thank you very much indeed. That's really interesting. Okay, so your point is, well, no surprise. So I've been saying, gosh, isn't it amazing? This is one way of putting it against myself, but I'll do that. Someone like Suarez is prepared to go as far down the line as he will with possibility, because your suggestion is that the concept of moral possibility is, in fact, there is an association with that, with absolutism and with this tendency to a certain kind of assumption of power. Whereas normally you would have this kind of diffuse landscape where people would, find a kind of way to act. Now, I think that's a really interesting point. I mean, I think that so I don't really like this term, but legal pluralism as a fact of the early modern landscape. You're never just in one forum. And so there are multiple fora, and the centrality of religion and the church and the role of that in society is actually part of that, and that's part of what this kind of thickness of the early modern subject, that you never stand sort of naked before the sovereign, if you like, or like you've got this this hinterland. But I mean, maybe so. I mean, there's quite an interesting contrast between Suarez and so Rodrigo de Arriaga and Juan de Caramuel. So we met them briefly yesterday. So they are writing in the context of the Bohemian Counter-Reformation, and they simply do not agree with Suarez. on this possibility thing or on the majority principle or any of that. And I think, and because they say, well, most people here are heritage. I mean, they just have to be squashed. So they really are, that they are more, if you like, absolutist than Suarez, and they don't want any of these possibility arguments. And I think what they're effectively saying to Suarez is that you are comfortable in Spain. This is a political culture in which everybody knows the names of the game, and this business of sort of temporizing with the law, that's okay in like the heartlands of the Counter-Reformation, where you've got this what I call a mature non-democracy. But that maturity is to do with that time that's developed. But in the newly sort of reconquered for Catholicism, that time is not there, and we're not giving you any of these possibility arguments. So I suppose there's something in my thought behind that possibility arguments are associated with a kind of mature culture where subjects have a certain kind of confidence. But I totally take your point that confidence is given partly by this rather sort of the fact that you're never subject just to one legal forum. So I think I'm halfway between the two options that you suggest, but I think that's an excellent point. Thank you.
Okay, I think we have time for just one more question. Philippa?
Yeah, thank you so much for these lectures. I wanted to pick up on a theme that was raised yesterday, I think, by Annie. So it's about the democratic potential of the possibility condition. So Annie, I think, was a bit skeptical that there truly is a kind of democratic possibility there, or at least there could be cases where the possibility condition could stand in tension with democracy. And in your reply, you distinguish between a democracy of subjection and democracy of sovereignty, and I found that very interesting. And I wanted to hear you say a little bit more about the democratic subjection, or what it means to be a democratic subject. I took it from your talk that there's at least two different ideas of what that might mean. So on the one hand, there's a kind of idea of the subject as someone who has rights against the powers that be. But that in and of itself doesn't seem, again, to be kind of particularly democratic. I mean, it certainly suggests a certain kind of person and a limit to sovereign power, but it's a limit to any kind of power, whether democratic or not. But I think there's a kind of stronger sense of the democratic subject, which is something like a subject who has the capacity or ability to determine what the limit of the law is. And you might think that as soon as we think of subjects in that way, like having those kinds of capacities to determine what the limit of the law is, that kind of opens up a route to thinking, well, if subjects can determine what the limit of the law is, why can't they just determine what the law should be? So I was wondering if you meant to imply that kind of stronger sense of the democratic subject or democratic subjection. But also, I was very curious about the intellectual history and whether it's in fact the case that that thought about the democratic subject sometimes kind of leads into the thoughts towards democratic sovereignty. So if subjects can do this, why can't they just make the law in the first place?
Yeah, so democracy as a form of sovereignty and as a kind of form of subjection. So, yes, so as I was saying in my reply to Annie yesterday, so this comes from the thought that, starting with this idea of a sort of gap between the legislator and the subject. Well, one way to close that gap seems to be just to make the subject into the legislator, right? So if subjects somehow consent to the law in some sort of way and they are involved in its legislation, well, then there shouldn't be any possibility gap. But I think there is. and this kind of democracy in which the person on the receiving end of the law is sort of absorbed into the person who makes the law, so you don't have a sort of distinction between the two, that seems, and no recognition of the possibility of that gap, that seems to me to be, I mean, part of this is how we're going to define democracy. But anyway, it's not a democracy I would want to live in, because to me, so maybe we are talking, with David, about a kind of rule of law democracy, or at least a democracy with space for an agency against the law. Sorry, I'm slightly losing. Yeah. So I think I want so there's a kind of democratic subjection which allows you to be which we want to be critical of the law. That's not the same as disobeying the law. I think I'm interested in a democratic subject as a kind of co-legislator as a subject, so that in our behavior as subject, and the fact that we don't necessarily, or at least there's some space for us not to obey the law, we are, that's a kind of democratic subjection in the sense that it's a kind of negative form of legislation, right? Or at least it's, as I say, it's an opening to rework the contours of legislation. So I think it is a political activity. I think it's a form of citizenship. This is why I'm quite interested in the way that these early modern theorists call this citizenship. And they're very keen on that. It's not just subjection, it is citizenship. So it is a kind of, so being a subject is a kind of political status and a positive political thing. So I think that's the way in which I intended it. But I really think that, yeah, I need to work some more on exactly, without it taking over the whole thing, the question of what elements of democratic thinking I really want to mobilize and which ones that I'm trying to exclude. Yeah.
Okay, so my apologies to so many of you who had questions. Hopefully we can continue the discussion over a glass of wine at the reception, which will take place just behind this wall here. But before we break for that, let's thank once again our lecturer and commentators.